Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a very important book and one that I think will be of great benefit to anybody who's involved in running a company. This is called Fiduciary Duties, and it deals with directors and employees, obviously of companies. It's in a second edition and it's been written by two people, Andrew Stafford, Queen's Counsel, and Stuart, Richie, Queen's Counsel. Now, my wife Elizabeth and I have produced a review of this book, which I think is a first-class book. We've given our review the title Tackling Corruption and Self-Interest, the new edition, that's the second edition, of Fiduciary Duties. Now, let's have a look at the book first. It's a hardback. It's a heavy book too. You see there it is, there's the front, and then there's the spine. Jordans have come up with an excellent book here. I'm very pleased with it. Let's go to the back first of all. You can see the detail in the index. It's done by paragraph numbering, which is important because as we get into the book itself, you can see, there's the front of the index at the back there. You can see how it's actually done. Now let's just go, we're right on procedural duties right at the end and issues right at the end. You see the paragraph numbering at the side and then you've got the footnotes at the bottom. There's a lot of it, obviously to link into the cases. Let's go right to the front. There's the actual front of the book there. You've then got some useful acknowledgements there. It's a heavy book. It runs to something approaching 550 odd pages. There's quite a useful piece of information there again. Then there's a forward to the earlier first edition, which was written by Paul Finn. And then you've got, again, the preface to the first edition there as well, and then the preface to the second edition. So there's a lot of prefacing going on. Then you get to the contents itself, and you see with the contents, you've got the title of the chapter, then a detailed set of contents of what's in it. After the introduction, you go straight into the main areas, and you can see it runs all the way through, and I'll just run through this for you so you can see the various chapters. Everything that you'd be looking for is here. There are 11 chapters ending up procedural issues at the end. Then you have the table of cases, not too many of them, I hasten to add, at the end of the day. Then a little bit on statutes, of course, you've got all the suspects there, Companies Act, of course, and then statutory instruments, and then we go straight into the introduction. And he starts off by saying, or they start off, a quick buck, a juicy contract, a head start. The temptations presented to a director or employee are numerous, and the moral fibre to resist them is all too often lacking. So, you see where we're going. Because you are, basically, when you are dealing with fiduciary duties, you're in a position of trust. And the law takes that very seriously. And this is really the theme, I think, that comes out of this book. At least that's when we were discussing what we were going to say about it. That was, to me, one of the important themes about what you must do and the responsibilities that are involved with holding this type of office. So what do we say about the book? We say this: since the first edition of this book was published in 2008, the hydra-headed issue of bribery and corruption in high places and low places has loomed ever larger and has now emerged as a centre stage problem over a wide range of human endeavours and activities, from banking to sport. I'm recording this in the middle of 2015 and we've just had the FIFA saga, which is continuing. Therefore, the clamour over the antics, say, of the international football establishment, based on the self-interest of its most prominent participants, is, as I say, a case in point. And this book was, of course, published before we knew what, or had some idea of what has been going on. And we still don't know that much as I record this clip. For lawyers then, especially those involved professionally in these complex matters of fiduciary duties, the publication of this book by Jordans, now in a secondary edition, is timely. In matters of self-interest involving a breach of trust, fiduciary duties owed to employers by both directors and employees have been abdicated, and the law as indicated in this carefully and thoroughly researched examination, has developed, it would seem, into a complex mass of contradictions. It's another area, probably, where we need to have substantial review and reform, but that's for another day. Fortunately, though, for perplexed practitioners, this book provides authoritative guidance and advice regarding the law in this area, although the frequent cautionary remarks throughout indicate that very little in this field of legal endeavour is necessarily carved in stone, so to speak. For example, it becomes difficult even to say with any precision what fiduciary duties are or what they encompass. In other words, identifying the very basic actions themselves. Judges and jurists, say the authors, have been unwilling to formulate any universally accepted definition of a fiduciary. I mean, obviously, what do you mean by fiduciary? Fiduciary means money, finance, but what does it actually mean? What one can say, however, that a fiduciary, specifically an employee in this context, is someone who has undertaken to or is obliged to act in the interests of another, hence the trust concept. Above all, fiduciaries must avoid self-interest in their dealing with their principals, and that it's common sense, and it must clearly be an established principle to start things off. These and any number of other points are helpfully illustrated by copious references to case law throughout the text, although for many lawyers the confusion quotient remains pretty high. It's quite evident that successive governments have not really managed to get a grip and impose a greater degree of stability on this mercurial state of affairs. Of course, help is at hand, though, within this 600-odd pages of the book. It manages in a single volume to harness a number of overlapping areas of law together as they relate to fiduciary duties, offering both an historic perspective and extensive commentary on how the relevant law can be applied in the courts. It's nice, logically thought and set out as a book, and I did find it relatively easy to navigate. As you would expect, the subject matter covering both employees and directors is diverse. There are chapters on contractual issues, bribes, proprietary and personal remedies, procedural issues right at the back, and much more. And for researchers, there are extensive tables of cases, statutes, statutory instruments, plus the frequent footnoting I've mentioned, and the numbering of the paragraphs throughout, which is actually a bit of a boon in my view for the index, because you get to something quite quickly that way once you know where the paragraph numbering actually is within the book. Let me conclude by saying this. Corporate lawyers, especially those interested in the developing jurisprudence relating to fiduciary duties across a range of organisations and entities, should, in our view, definitely acquire this book. And I think you will find it of great help as a companion if you've actually got that responsibility and really do feel you want to have something which can advise you on what you might or might not do in certain rather difficult circumstances, and I think that is actually a help to you. And as I've indicated, the publication date is March 2015, and I'm recording this in the summer of 2015. There is the book itself, nice purple cover, hardback, spine, nothing on the back. Let's just open it in the middle. Unlawful competition, right in the middle, there we go. You've got the footnoting, you can see that. You've got the nice paragraph numbering, useful subparagraph subheadings, corporate opportunities and so on. And it runs all the way through. There's a lot of information here which will be of great help. Bribes, special chapter number 6, dealing with bribes. Should be compulsory reading for certain people. No names will be mentioned. But we are beginning to see even today, as the public become more aware and are told more and are educated to a higher level about what's going on, we suddenly begin to realise that some people have been at it for some time at the expense of everyone else. And of course, one of the biggest problems, this is one of many books on corruption, it's a worldwide problem. and it's not going away. It's, if anything, it's getting worse. And you can see, because of cultural problems, racial problems and all the other issues that are connected with it, that it's a very, very serious, difficult, emotive and fundamentally possibly irreconcilable issue at the moment, until we have perhaps some agreement internationally as to where we're going. At least this book will give you some idea of what you've got to do if you're running a company with the financial responsibilities. So thank you very much to the two authors. I think they've done a wonderful job. Andrew Stafford, Queen's Counsel, and Stuart, Richie, Queen's Counsel, and also of course to Jordan's for producing an excellent book up to the very high standards. And as I've said on many occasions, we can't do without these books, because they really do make our lives as practitioners a great deal easier. Thank you so much. Bye bye.